This argument today is not about the right for Donald Trump to run for president. This is about your right to vote for him. The Democrats in Colorado, the Democrats in Maine, in the Secretary of State's office, the Democrats in any other state that are trying to do this, they're not trying to stop Donald Trump from being president. They're trying to stop you from even having the opportunity to vote for Donald Trump for president. This is an attack on you. The Supreme Court is hearing arguments in the case of the state of Colorado deciding unilaterally through the Supreme Court that Donald Trump cannot appear on the presidential ballot. Now, they made this argument based on the 14th Amendment that says a person guilty of insurrection against the United States can't hold federal office. But see, here's the problem. Donald Trump hasn't actually been charged with insurrection, let alone convicted. He hasn't had due process. He hasn't even been able to defend himself against a charge that hasn't even been levied against him. But that's not stopping the state of Colorado. They went ahead and decided that the people of that state can't vote for Donald Trump. They don't have the opportunity to do it. The arguments are going on right now, and we've got a little snapshot here into how they're going. We'll start with Clarence Thomas, because his line of questioning was, well, rather brilliant. And the person who's making the case that you shouldn't be able to vote for Donald Trump, he floundered. He floundered a lot. Watch.
States have created under their Article 1 and Article 2 powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified.
Now, I'm going to let you finish, Justice Thomas, in just a second, but I just want to point out for you all how important this line of questioning is. First of all, Clarence Thomas is doing something really pesky that the left hates when he does. He's actually bringing up history. He's actually bringing up the facts at hand at the time the 14th Amendment was voted on, ratified, and passed. He's bringing up the context and the reason why we have a 14th Amendment. It has to do with the Confederacy. It has to do with the Civil War. And at the time, they wanted to make sure that anybody who waged war in insurrection against the United States of America in the Civil War would not hold federal office. It's that clear. It's that simple. And so what Clarence Thomas is asking here, and then I'll let you see how this questioning goes, but he's asking something very simple. Since the advent of the 14th Amendment, in the middle of the 19th century, over 160 years ago, has there been one example where a state, like Colorado is doing right now, where a state has precluded a person from running for office, for federal office, based on the 14th Amendment provisions? He's asking for one example in the history of the country since the time this was passed. Give me one example, counselor, of this happening before. Now watch how the questioning goes.
If your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting.
So what's the purpose
officer.
of what was the purpose of the Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states.
I understand that. I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand you look at Foner or Foote, Shelby Foote or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s. And by the 1890s, everyone had received amnesty and these issues had become moot. So I don't think the history tells us.
Sort of look at Justice Thomas's question sort of from the 30,000-foot level. I mean, the whole point of the 14th Amendment was to restrict state power, right? States shall not abridge privileges of immunity. They won't deprive people of property without due process. They won't deny equal protection. And on the other hand, it augmented federal power under Section 5. Congress has the power to enforce it. So wouldn't that be the last place that you'd look for authorization for the states, including Confederate states, to enforce, implicitly authorized, to enforce the presidential election process? That seems to be a position that is at war with the whole thrust of the 14th Amendment and very ahistorical.
So huge. And that's, of course, Chief Justice John Roberts jumping in there at the end. And listen, it's a lot of talk, and I appreciate your patience here going through this video here, which is really just an audio track of these arguments. But you see what they're getting at. There's absolutely no historical basis for what Colorado did here, ever. And you even heard the lawyer representing Colorado there conceding the fact that 30 years after the Civil War, this was moot. They actually rescinded any restrictions on anybody who may have participated in the Confederacy 30 years after the 14th Amendment was ratified. So even that aspect of the 14th Amendment, the whole reason the 14th Amendment was passed, was rendered moot 30 years later. And now they're trying to employ it against Donald Trump in 2024, 160 years later. And there's literally no historical basis for it, not for a state to do this. And John Roberts at the end there made the point. What you're suggesting that the state can do here is ludicrous on the face of it, that the idea that the 14th Amendment was ever meant to be employed here, because the whole point of the 14th Amendment was to stop the Confederate states from presenting someone from the Confederacy for federal office. So, of course, the state Supreme Court would not come in and tell the state not to do what the federal government was keeping the state from doing. It's the federal government's job to do that. It would be Congress that would do it. That's the whole point. There's no way Colorado can unilaterally make this decision. Oh, but I know what you may be saying. That's Clarence Thomas and John Roberts. They're crazy right-wing Republicans, right? They might as well be insurrectionists too. Okay, you're not saying that, but you know your liberal buddy is saying it. Okay, well, how about Elena Kagan? She also jumped into the questioning, and she asked, honestly, one of the most fundamental, important questions of this entire proceeding.
Most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, you know, this question of whether a former president is disqualified for insurrection to be president again is, you know, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, you know, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, you know, what the Michigan Secretary of State did is going to make the difference between, you know, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
So you'll hear the answer in a second, but this is, again, a fundamental issue here. When you heard her say, it sounds pretty national to me. If you're saying that a president is ineligible to run if he has been found to have caused an insurrection against the United States, that's all federal office, federal discussion stuff, not something that a single state can decide for the rest of us. And by the way, just a quick tangent, that's the argument many of us were making after the election of 2020, when we saw single states using brand new and unqualified and untried and trusted methods of counting and accumulating and qualifying their ballots to determine who the members of the Electoral College would be. Why should one state like Georgia or Arizona or Pennsylvania or Michigan or Wisconsin be able to decide for the rest of the country who the president's going to be based on these brand new crazy methods of qualifying mail-in ballots and determining whether those ballots were fraudulent or not? But I digress on that only a little bit, because that's what got us to January 6th in the first place. But let's get back to the argument here.
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further. And
that's really because that was a real tricky thing that the judge said, well, it's not Colorado deciding. You guys are going to decide. But that's not the case, actually. The Supreme Court decision that's in front of the court right now is not to decide whether Donald Trump can run for office or not. I know that you'll see people in the media and on cable news sort of shorthand it that way and make it sound that way. But that's not technically what they're deciding. What they're deciding is whether Colorado can decide if Donald Trump can be on the ballot or not. That's the argument. So this is, the Supreme Court is not making a federal national decision for the country. They're just saying whether Colorado can make this decision unilaterally. And that's what she points out here. But it's an incredibly important and deceptive answer from the attorney. You see how they're trying to do this, right? You see what they're trying to do to you to take you out. And I just want to be clear here, just real fast, because there's more of these arguments. This is not about Donald Trump's rights. This argument today is not about the right for Donald Trump to run for president. This is about your right to vote for him. The Democrats in Colorado, the Democrats in Maine, in the Secretary of State's office, the Democrats in any other state that are trying to do this, they're not trying to stop Donald Trump from being president. They're trying to stop you from even having the opportunity to vote for Donald Trump for president. This is an attack on you, not on Donald Trump. All right, back to the arguments.
And saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, you know, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck. The first mover state here, Colorado, we're stuck with that record. And, you know, I don't want to get into whether the record, I mean, maybe the record is great, but what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, you know, the hearsay rules are, you know, one-offs? Or what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, you know, that we made with Mr. Mitchell too, that it just doesn't seem like a state call.
Yeah, and a lot of legalese there, but let me just break it down for you. What Justice Coney Barrett is saying there is that we're going to get stuck with this decision. You know, this is Colorado. Colorado's the first one up to the plate. And whatever we decide here about what Colorado has the right to do with regard to disqualifying a candidate from the ballot based on the 14th Amendment, it's not like when another state comes up to us with the same argument that we can then say, oh, but in Maine, it's a different story. No, this is, you're forcing this national decision based on what this one state has done. And it's clear that the state does not have the power to do this. At least it's clear for me. And it seems pretty clear from the arguments that are being made, or at least the direction these arguments are going. All right, real fast, one more aspect of the Supreme Court's arguments today. This came from Brett Kavanaugh. And frankly, I think this is the most important, most compelling point of all. And Justice Kavanaugh makes it very succinctly here. It's not a long clip. Let's go to it.
He had the opportunity to call witnesses remotely. He didn't use all of his time at trial. There was ample process here, and this is how ballot access determinations in election cases are decided all the time.
Okay. Second question. Some of the rhetoric of your position, I don't think it is your position, but some of the rhetoric of your position seems to suggest unless the states can do this, no one can prevent insurrectionists from holding federal office. But obviously, Congress has enacted statutes, including one still in effect, Section 2383 of Title 18 prohibits insurrection. It's a federal criminal statute. And if you're convicted of that, you are, it says, shall be disqualified from holding any office. And so there is a federal statute on the books, but President Trump has not been charged with that. So what are we to make of that?
And there's literally no answer to it, because that is the slam dunk, game over, pack your bags, go home, Colorado. This is over question. You're claiming that Donald Trump is ineligible from being on the ballot for president because he's guilty of insurrection. And the 14th Amendment says that someone guilty of insurrection can't be on the ballot. And yet, not only has Donald Trump never been found guilty of insurrection, he's never had the opportunity to defend himself from charges of insurrection because Donald Trump has never been charged with insurrection. So how exactly does the Supreme Court of Colorado just decide, well, he's guilty of insurrection, so he can't be on the ballot? Now, they claim it was based on the findings of the January 6th Commission. Thank you, Liz Cheney. But that's ridiculous. Not only did he not have a chance to defend himself, again, little thing called due process in our country, from the charges of the January 6th Commission, but his own political party was precluded from being represented on that commission. And finally, and most importantly, we have a mechanism in the Constitution to find a president guilty of high crimes and misdemeanors. It's called impeachment. And he was impeached for January 6th, and the Senate did not convict him. So by definition, he is not guilty of the charges that were in that impeachment related to January 6th. So how can someone be kept off a ballot for insurrection when he hasn't actually been found guilty of insurrection? And that's truly the crux of these arguments today. But I do want to remind you, no matter how this decision comes down, and I pray not only that the Supreme Court rejects what Colorado and Democrats are trying to do to you, but I pray that it's a unanimous decision. We can't handle a 5-4 decision. It will continue to divide us. I hope Justice Roberts figures out a way, Chief Justice Roberts figures out a way to get a unanimous or near unanimous decision out of the Supreme Court. It would be so critically important. But understand this, if you take anything away from this entire proceeding, this is not about Donald Trump. It's not about Joe Biden. It's not about Republicans and Democrats. This ultimately is about you. They are terrified that you're going to vote for someone that they don't approve of. They are terrified that you will actually do what you did in 2016 and in 2020 and vote for a man that they just can't imagine being back in the White House again. They're doing whatever they can to take your vote away from you.